これよりパネルディスカッションワーキングセッション2を開始いたします。テーマは模倣品対策のための官民連携、国際連携です。パネリスト、モデレーターの方々につきましては、ワーキングセッション1と同じでございますので、ご紹介を省略させていただきます。それでは、ここからの進行をモデレーターのお二人にお願いいたします。小野寺弁護士、相良弁護士、どうぞよろしくお願いいたします。
はい、それでは、セッション2を始めたいと思います。皆様、お疲れムードが漂っておりますが、最後のセッションを頑張ってまいりましょう。はい、セッション1ではですね、各国におけるプラットフォーマーによる模倣品対策についてご紹介いただきましたが、e コマース上の模倣品に対しては、官民それぞれが独立して対策を講じるのではなく、官民が連携することによってより効果的な対策を講じることが可能となります。さらに、国際的な課題である e コマース上の模倣品問題に対して、各国が国際的な連携を強めることが求められています。そこでワーキングセッション2では、模倣品対策のための官民連携、国際連携をテーマとして、各国の状況について議論や意見交換を行っていきたいと思います。まずクエスチョン3では、模倣品に対する効果的な取り締まりのためのプラットフォーマーとの官民連携としてどのような取り組みをしているか、また今後どのような連携が考えられるかという点を伺っていきたいと思います。まず、現在どのような取り組みをしているかについて、具体例として日本での取り組みをご紹介いたします。日本では、特許庁に模倣品対策室が設けられていて、官民連携の総合窓口のような役割を果たし、さまざまな情報提供がなされています。また税関においても、定期的にブランドオーナーなどによる税関職員のための識別研修が開催され、水際規制の強化が図られています。なお、最近の法改正では、商標法及び商法において、海外の事業者が模倣品を郵送等により日本国内に持ち込む行為について、権利侵害行為となるということが明確化され、海外の事業者が郵送等により日本国内に持ち込む模倣品が、輸入してはならない貨物として、税関の取り締まりの対象となりました。これらの改正法は、昨年10月1日に施行されています。また昨年6月にはですね、税関とアマゾンジャパンとの間で水際取り締まりにかかる模倣品等の水際取り締まりにかかる協力に関する覚書というのが締結され、取り締まりのための協力をしていくことが約束されました。EC 事業者と税関との間の、MOU、覚書というのはこれが初めての事例と言われています。さらにですね、模倣品海賊版の海外における知的財産権侵害問題の解決に意欲を有する企業や団体が政府と連携を強化しつつ、国内外の政府機関に対して一致協力して行動することを目的として、国際知的財産保護フォーラム、略称を IIPPF と言いますが、そういう団体が2002年に設立されています。現在 IIPPF は206の企業、90の団体が、2022年現在の数字ですが、メンバーとなっていて、ジェトロを幹事としてさまざまな活動を行っています。ちなみに、日本における大手プラットフォーマーの一つである、楽天株式会社なども、IIPPF のメンバーになっています。で IIPPF も、海外の権利者団体である、ブランドオーナーズプロテクショングループというところと MOU を締結したり、 アマゾンジャパンとの間で、MOU を締結したりしているというのが、日本における状況です。このように日本ではですね、政府が積極的にいろいろな情報発信をするということもやっておりますし、IIPPF という団体を通じた取り組みというのも行われているわけですが、他方たくさんのプラットフォーマーが当事者になっているような大きなその MOU といったものは、存在していないというような状況です。これに対してですね、先ほど基調講演の中でもご紹介いただきましたけれども、大手プラットフォーマーやたくさんの権利者ブランドオーナーとさらに政府との間で締結されているMOU が締結されているという国がいくつかあるようです。先ほどタイではインターネットにおける知財保護に関して2種類の MOU が締結されているというご紹介がありましたので、まずこの点をタイのナバラトさんに聞いていきたいと思います。質問に関してはちょっと英語で質問をさせていただきたいと思います。So, Navarata-san, I'd like to ask you the first question. I was impressed that you have two MOUs, and under that MOU, that 99% successful rate to take down the counterfeits. So, what do you think is why it is so successful, and what is the good point, do you think, for your country's system?
Thank you for the question. As you said, that it's 99% is going to be about the website blocking, that we can take it all, we can block it all, that we got the notification, it means 99%. But the effectiveness of that is, I think, is the GIP. My department can be able to get involved and get close to the stakeholders, especially the IPR owners, that we can have the discussion and solve the problem or developments in preventing the violation with the stakeholder, even the service provider platform, and also it's allow us to process the violation more quickly. So that's why it can be effective.
非常に緊密に話し合いをしながら進めていらっしゃるということ。And I'm also curious about the MOU for online advertisement. Do you think it's also effective for anti-counterfeit?
Thank you for the question. I think it's very, very useful, and another important mechanism that we can use, because as I already mentioned in the slides, that of course the advertisement is important to every website. So if we can block infringing a website, so the owner can get more, I think, more revenue or more money from the right, from the right person. That's if you have the fake advertisement in the website, so I think it's gonna be no one can be participate in the website. Thank you.
Thank you. お金の流れを断つというところが非常に有効であるというコメントをいただいたと思います。この点で非常にタイの方では 知的財産局が主体的に関与されて、積極的に模倣品対策を講じられていると、理解いたしました。引き続きましてフィリピンですが、フィリピンでもフィリピン知的財産庁が民間と連携して積極的な活動をされているようですので、フィリピン、これを動かしてなかった。はい、フィリピンのですね、伺ってみたいと。クリスティーナさん、
We also have private-public partnerships or collaboration among brand owners, intermediaries, and government, because we believe that this is crucial to address counterfeiting and piracy. That is why in the Philippines, we also have the Memorandum of Understanding between online platforms and brand owners, which we call the e-commerce MOU. So this covers brand owners, industry associations, and chambers of commerce, as well as online platforms. The purpose of which is to build a stronger industry-wide coordination mechanism. And its main objective is to establish a code of practice to address the proliferation of counterfeit and pirated goods over the internet. And although IPOFIL is not a signatory to this MOU, but we serve as the intermediary between brand owners, industry organizations, and e-commerce platforms. And this MOU has been cited as a best practice in cultivating online trust to deter illicit trade in the ASEAN region. Some of the salient features of the MOU are the following. There's a moratorium on litigation, meaning all signatories, both e-commerce platforms as well as the brand owners, agreed among themselves not to initiate any new litigation against each other concerning matters covered by the MOU until the end of the period of the MOU implementation. Second, there are provisions regarding proactive and preventive measures whereby both online platforms and brand owners commit to undertake proactive measures or commercially reasonable and available steps to effectively fight counterfeiting and piracy. And there's also provision on the policy on repeat infringers. It provides for a policy on repeat infringers wherein the signatories will cooperate in the detection of the same and in meting out appropriate penalties to repeat infringers. There's also provision on the cooperation and information sharing with each other and with the law enforcement agencies for proper investigation and prosecution. And this MOU will be assessed, its implementation under the auspices of the IPOFIL. There are 4 KPIs or indicators being used for this one, which have been agreed upon by the signatories. So first is the number of search results that link to an offer of alleged counterfeit and pirated goods. The second KPI would be the number of listings removed by the platforms as a result of its proactive and preventive measure and report. Third is the number of permanent and temporary sellers restrictions imposed which are linked to alleged infringement. And lastly, measures or procedures explored to generate the key performance indicators. So this is one of the public-private partnership, but we also have an MOU. The IPOFIL has an MOU with internet service providers to combat online piracy, where ISPs commit to take down infringing piracy websites. And this MOU will take effect in November of this year. And IPOFIL also has collaboration with different organizations by engaging into constant dialogue with stakeholders and partners and entering into bilateral MOU to further strengthen the collaboration. Some of the MOU we have are with the Philippine Retailers Association, Motorcycle Development Program Participants Association, the CONWEB, or the Confederation of Wearable Exporters of the Philippines, in order to protect consumers and IP rights holders against sale and manufacture of counterfeit products, both in the physical and online markets. We have also partnered with the Pharmaceutical Security Institute to address the sale and proliferation of counterfeit pharmaceuticals. And lastly, aside from this, the Philippines established the National Committee on Intellectual Property Rights, or the NCIPR, which is composed of 15 member agencies of the national government, which include the Ministry of Trade as the chair, the IPOFIL as the vice chair, and we have law enforcement agencies involved here. We also have the Bureau of Customs and also the Bureau of Internal Revenue, the Bureau of Immigration, and soon we will be having as a member the Anti-Money Laundering Council because based on the law of the Philippines, violation of IP right is considered as a predicate crime for terrorist financing. So that's why we involved also the Anti-Money Laundering Council. And this committee was established in order to provide also workshops and trainings for the law enforcement agencies in collaboration with the brand owners for us to be able to train our law enforcement agents on how to detect counterfeit items, how to detect pirated goods, and also we provide trainings also for our judiciary and prosecutors in order to help them and to enhance their knowledge and expertise on how to prosecute cases on intellectual property rights. Thank you.
Thank you. Thank you for your information. So, there are so many information included, and I try to follow. But so in the Philippines, you have several MOUs with not only e-commerce MOU, but you have a lot of MOUs with the organization of various kinds of fields. And also you have a lot of customs or agencies for the criminal issues and also the training sessions like by the IP owners. Am I right?
Yes.
Okay. So, ここから日本語すみません。フィリピンでもですね、今皆様ついてこられたでしょうか。たくさんの対策が、講じられていますというご紹介をいただきました。こちらもやはり MOU を民間と知的財産庁が締結して、官が結構主体的に動かれているのかなという印象を持ちました。カンボジアでもですね、いくつか MOU が締結されているということですので、カンボジアの、ケオさん。
Yes, ma'am. Good afternoon.
Good afternoon.
Sir, ma'am, yeah.
Can you introduce the MOUs in your countries, and also you, if you have any other partnerships or activities, could you please introduce?
Okay, thank you, ma'am, for giving me the floor. I'm Major General Kelly from the Counter-Counterfeit Committee of Cambodia. I will go briefly about the background of my organization and some public and private partnership and some international cooperation with other countries. Our committee was set up by the real government of Cambodia since 1914, in which there are 14 ministries and institutions as its members, including Ministry of Justice, Ministry of Commerce, Ministry of Industry, Science, Technology and Innovation, Ministry of Health and Fine Arts, and some other departments such as Department of Customs and Excise, Department of Taxation, etc. And since its inception, we had worked closely with those ministries and institutions in combating counterfeit products, and also including capacity building and raise awareness among the public about the harm effect of the counterfeit products. And among those years, since its creation, we can say that we apprehended 23 infringers and sent them to court for prosecution. And also more than 2,000 tons of counterfeit products were seized and incinerated or disposed. The CCCC also cooperated with some Cambodian National Commission for Consumer Protection, the Directorate General for Consumer Protection, Competition and Fraud called CFF, which is now very active in Cambodia and very efficient organization, very powerful now in combating those counterfeit products and also illegal products in terms for protection the consumer. And also we work with the National Committee for Intellectual Property and also with the Department of Economic Police of the Ministry of Interior. And also we also has worked closely with some legal partners such as some local partners such as Intellectual Property Association of Cambodia, also one of the key players in giving advice and also help the IP owners to protect their rights, called IPEC. And also we work with the European Chamber of Commerce of Cambodia, called Eurochamp, Association of Women Entrepreneurs of Cambodia, Association of Cambodia, the Association of Union of Investors. That those associations has hundreds of members. There are investors, there are business owners that work with them, and also we also now working with Japan Tobacco International (JTI) and Lee Food Service, a big company here. And those companies we had already signed MOU with them for the purpose of combating counterfeit products, also in information sharing and also for capacity building. We organize training to have well aware of the harmful effect of counterfeit products and also to know to distinguish between the genuine and fake product of the brand owner. And so we also train our team to train abroad and also train locally. But at the meantime, we have some local platform provider here, but we don't have cooperation with them yet, actually. Those famous like Khmer 24, K24, Digital Cambodia, Alibaba.com or Amazon.com, but unfortunately we don't have close cooperation with them yet, but we expect that we will have good cooperation with them in terms of cracking down on counterfeit products. And also we are working with a young platform provider called Global Cleantech Innovation Program that is created by young entrepreneur. I can raise some example that I answered the question earlier about the popular way for displaying their products online now in Cambodia is especially Facebook, among other like maybe the international one like Alibaba or Amazon, but Facebook is the most common way for people selling or displaying their products online because it's very practical, easy to use. Only one person can run their show by doing the live streaming to showcase the product online, and it's easy if it is found out that it's the fake one or illegal one, so they just close down the page and change the address. So that is very practical for them, and it's hard for our officers to cracking down on them. And if we cannot find enough evidence or legal evidence and other necessary evidence, so we cannot conduct the raiding. And at the moment, I mean, since the creation, our top leaders has tried to cooperate with and to learn from other international countries, such as our bosses, our top leaders, organize and exchange visit to some different countries, such as we went to Thailand to study to work with the Ministry of Commerce of Thailand and DIP in the previous 5 years to exchange view and learn from them. And also we went to Malaysia to train about how to use the platform like a SIGPA that is good in providing a barcode for products. And also we study with Vietnam, which is very strong under the Ministry of Security that in charge of counter-conflict products. And also we had a team went to Switzerland, to Morocco, to France, and to China. And now we are working with a big company in China to adopt the barcode system. And also we went to the Philippines. And lastly, last year in December, our team went to Australia to work with the Australian competition and consumer competition. So this is our way of working here, and I'm very happy to answer some more questions for businesses that run in Cambodia and they have problem in terms of want to file a complaint or how to fight the infringers in Cambodia. I'm very happy to cooperate and to answer your questions. Thank you very much.
Thank you for your comments, and your comments get into even question 4, I feel like. But thank you for. So I understand that the Cambodia is also CCCC, especially, is very active for anti-counterfeiting, but still struggling to attack the Facebook transaction through Facebooks or the big e-commerce in Cambodia. And so it seems that the Cambodia government is really active to sharing information with other countries. Thank you. というわけで、カンボジアもですね、ケオさんがCCCC の方でいらっしゃいますので、非常に CCCC を中心として模倣品対策頑張っていますというご報告だったかと思います。続きましてですね、各国 MOU に基づいて官民連携の取り組みが行われているというご紹介があるのですが、マレーシアではですね、MOU が締結されているというわけではないですけど、政府とプラットフォーマーの間で、情報共有などの取り組みがなされているというご紹介があります。ので、マレーシアのカラさん、could you please explain the system in your country regarding the information sharing, including the account information or email address or that kind of information sharing among the governments and platformers. So
all right. Okay. All right. Okay. As you have mentioned, yes, in Malaysia we don't have any MOUs between the platformers and associations or companies. However, we have the law to actually regulate the platforms, or we call it the Consumer Protection Electronic Trade Transaction Regulations 2012. And under this law, all e-commerce platform who operates, they supposed to maintain records of the names of the traders who actually sell goods through their platforms, and registration numbers of their business or company, email address and telephone. So this is where it helps us as the agencies from the government or the ministry when we require, if there is a certain kind of criminal offences conducted, or there's a complaint from a public or even a consumer regarding some misconduct or certain trade or whatever that they've been bought or whatever. If there is a complaint, we as the enforcement agency under the ministry, we have the rights or have the power under that particular regulation where we can actually request for information and particulars of those traders. And with these particulars, we usually will try to kickstart our investigation and trail them. And one of it, we can even request for their account numbers. And through the account numbers, we will usually follow up with the central bank to get more particulars to trail or trace. Where does that lead them? So this is how we work. So we have the we call it the Electronic Trade Transaction Regulation, which actually helps us in that. And currently, we are also looking at these regulations. We are trying to improvise the existing regulations, because at the moment it's just about maintaining records. So the ministry is looking at improvising these existing regulations as well.
Thank you. So the information is basically from platformers to the government and not from government to the platformers?
Yes, if we remember from the earlier discussion, it's a little bit difficult for the trademark owners or the business themselves to actually require information directly from the platformers. So if it's any assistance, serious offense requires assistance, they come to us, because we have the power to actually seek all this information that we want from the platformers. So it's not public or industry or brand owners or trademark owners or copyright owners can't actually get this information directly.
Thank you. マレーシアではですね、MOU ではなくても法律でもう情報が取れるということのようであります。かなり強力なあれですね。でも個人バンクアカウントの情報まで取れて、もう銀行の方までその情報を持ってってということができるということのようです。ここまで伺ってきた中では、かなり政府の方が積極的に官民連携といっても、官が結構主導的にやっている国も多いようですが、先ほど基調講演いただきましたシンガポール、こちらはですね、どちらかというと民が結構いろいろやっている印象を持ちました。やはりシンガポールにもMOU、大きなその MOU といったものはないということと理解しておりますが、カルーセルでの官民連携の事例を少しセレナさんにご紹介いただきたいと思います。So, Serena, could you please introduce the Carousel's activity with the public?
Thank you, Yuriko-san. So, for Singapore, we have an authority called the IPRB, which is a branch of the Singapore Police Force that specializes in ensuring or protection of intellectual property rights. So over the years, we have worked very closely with IPRB, and we also have a more recent one, which is a tripartite agreement between the Singapore Police Force, Carousel as a platform, and the rights owners themselves, where we have a fast-track takedown mechanism, so similar to what many of the panelists have shared earlier already, where there is a designated channel, so we know specifically where which emails, for example, these takedowns will be sent by, and we will act upon them, and we have a designated team monitoring for emails from this specific channel. So that's one of the examples that we actually have, but over the years as well, we have also there's a lot of sharing of information and data that we have with the authorities in Singapore. So there are, for example, they might have done an entrapment purchase where they buy an item off one of the users and they have confirmed that the item is actually a counterfeit. We will get information as well so that we can be more mindful. What we can do is potentially hide the listings of that seller, but yet not trigger the seller's attention, and yet at the same time, other buyers will not be able to see potential infringing listings while the Singapore Police Force or any other authorities actually execute their process of charging that particular individual. And of course, when they have the different court orders or enforcement orders against the individuals and warrants to get more information from the individuals, we will also support and actually providing and assisting with the investigation. So maybe Vignesh can also comment a little bit more about it, but there are different regulations that require us to provide information as well.
Yes, thank you very much. It's interesting to hear this because I've been in practice for almost 20 years. And when I first started out, the intellectual property rights branch of Singapore of the police force was in a division of the police force that we work very closely with. But the people that they work closely with were the IP owners. So it was the IP owners who would work with the intellectual property rights branch to teach them how to identify counterfeits. And when they have identified counterfeits in the marketplace, they would be calling the IP right owner and telling us, well, there's a physical marketplace, there's a counterfeit, we have bought something, and would you like to take action? Yeah, and they would go with us to get the search order, the warrant of arrest, and we'd go physically as the IP right owners, lawyers, to seal the physical seller's place of business and to shut down the seller. That was the way it used to work. But what has happened, and that's very interesting, is that now the IP right branch sees the value in actually engaging the e-commerce platform rather than the IP right owner, and that the e-commerce platform is actually stepping into the position of the IP right owner to prevent the merchant or the seller from even selling on the platform to begin with. And I think that's a welcome development.
Thank you for your comments. And also, I'd like to ask Vignesh-san regarding the TSR in Singapore. Because so in Singapore, there are many platformers are really actively doing anti-counterfeiting activities, but the TSR is also a kind of the public will reaching the platformers. It's a very interesting system. So I'm really curious about that system. So the general consumers will check the rating usually, or not so much. Well, it works actually in Singapore.
That's an interesting question. You must remember that the TSR is a very new system that we have. It's only a year old. So to be frank, I can't say whether the system is effective as of yet. And I can't really comment as to whether the users would actually check the rating score before they make a purchase. What I would say is that there is a framework of the public authorities actually rating the platform. In a way, you are understanding what the public authorities think of you as the platform. And that's good feedback. It's indirect feedback, but it tells you how you are to engage with the public authorities. And the public authorities are flagging out what are perhaps a deficiency in that particular platform, and it's up to the public to run that risk, ultimately, at the end of the day. And my purpose for bringing the TSR is that it was initially conceived as a system to prevent scams, because scams are a problem in our online marketplaces, and that was the more pressing concern on the part of our government at the point in time. But the TSR rating system, to my mind, can be also used to protect the rights of IP owners and really to just prevent the sale of counterfeit goods, because the TSR system is meant for the public good. And we have laws in Singapore that protect consumer rights, the Consumer Fair Trading Act and the Sale of Goods Act, which I touched on in my keynote speech earlier. And when it comes to counterfeit products that affect the health and safety of your public, then this is the public good that we're trying to protect here. So the TSR system can be an effective tool. It has to be changed or tweaked slightly to address the concerns of IP right owners. But the ultimate motivation is for the protection of the public good. And then I think the users, being the public, will actually check the rating, and then I think it'll be effective. And I hope to see that happen in due course.
Thank you for your comments. 私個人的には日本にもこういう制度があるとサイトで買えば安心だということになりますので、またその模倣品対策に熱心なプラットフォーマーがどこなのかというのが一目瞭然で分かるというのはプラットフォーマーのインセンティブにもなるのかなというふうに思ってすごく興味深い、制度だなと思います。はい、それでは次に今後どのような連携が考えられますかというご質問に移りたいのですが、まだご発言いただいてない国の、方々に、今後の連携、今現在はそれほど連携がないんですよというふうなご報告があったんですが、今後どのような連携が必要とお考えか、今後各国で、考えられている官民連携、どのようなものがあるかをご紹介いただきたいと思います。まずラオスの、キパちゃんさん。Could you please introduce your country's potential partnerships?
We should have the MOU specific about previous settlement with the e-commerce platform to protection about the counterfeit product and have a preparation about the government and the private sector to solving this problem. Actually, we have a cooperation about the private sector, public and government. We have some workshop and seminar and giving the knowledge about the IT engagement now, but we still don't have the MOU between the government and private public. And I think if you have this mechanism to help us to control about the IT engagement in Laos, it would be helpful and helpful to protection the right owner. Thank you.
Thank you for your comments. Your voice was really a bit hard to listen because of the connection issue, maybe. But in your countries, there also there is a partnership between public and private sectors, and try to maybe considering to conclude a kind of MOUs. Is that correct?
Yeah, we have cooperation with the private sector already, and but in now we have just only giving the knowledge and giving some training, giving their to understand more about the law to protection the IP infringement. But we have planned to have MOU about the specific about the IP dispute settlement with the e-commerce platform. Yeah, but maybe in the future.
Thank you.
Yeah.
今後より一層知財保護を強化していこうということでラオス政府も、検討しているというご紹介をいただきました。続きましてインドネシアですね。インドネシアも今後 MOU の締結が検討されているというようなコメントをいただいておりますが、金さん、could you introduce your country's potential movements regarding public and private partnerships?
So if you can see my screen, so far there's only one MOU that's concluded. That's between Tokopedia, a very major e-commerce platform, and the DGIP, the IP Office of Indonesia. And if you can see from the screen, basically this is in reaction to the USTR priority watch list. It seems to be a reaction to the USTR rating that this happened. But this MOU is quite general still. So this MOU is on the dissemination of information between Tokopedia and the DGIP on protection of IP. So again, it is still quite general, and we have not seen actual examples of implementation of this MOU, and we don't have the specific text of this MOU. So it's still unclear how this will actually implement and whether it's really useful in practice or not, and whether this is only in reaction to the USTR. So a lot of actions that's been taken now in Indonesia is because of the USTR priority watch list that's being taken against Indonesia. So then we are seeing some lobbying from a lot of foreign government. One of this is the Korean Trade Investment Authority. They are lobbying for a better MOU than what has already been done. So this meeting happened 1 month later after that Tokopedia MOU. So it is quite clear that the MOU that has been signed with Tokopedia is insufficient. So the most important thing of any, so there has been some discussion even from the UK IPO, so from several foreign governments.
I'm sorry. So the other, the website you showed is a website of DGIP. It's a Indonesian patent office.
That's the website of DGIP that
it's an official website.
Google
Okay.
Translate. Yeah. So what is being proposed to the DGIP is an MOU that need to cover these 3 basic points. The first one is a clear criteria for banning a merchant from repeat or future posting. The problem with Indonesia is that a merchant can have many posting. So if you want to do, so one merchant can have like maybe 20 to 50 postings of infringing products. So if you want to take this down one by one, it's going to cost a lot of money, and this is how some of the service providers are doing, which is very tedious. So what we are pushing now is for the banning of a merchant. And the problem with this merchant is that they are either using nickname or they have multiple posting. So we have acted for a merchant. Well, no, we have acted for IP owner where we succeeded in having a merchant ban. But that takes a lot of effort, a lot of follow-up actions. And it's still unclear what kind of criteria they are applying because they don't want to be transparent about that. And the second key point about the MOU should be merchant identification. So some of the basic excuse coming from the platform is that, these are personal data, so they are subject to the data protection policy or the laws of the country. But we are trying to clarify this with the platform that, they are coming on as merchants. So this should not be personal data. And so that's what we are pushing. And some of the foreign governments are trying to push for this as well, that merchant data cannot be considered as personal data because they are selling as a seller. They are not your single seller that's selling a second-hand product, a one-off thing that they have a handbag they want to sell. They are operating as a business, so that's what we are pushing. The next thing is this: the key ingredient of the other MOU that we are pushing for is that there must be an ongoing review system. This is how we avoid lawsuit against the platform. Because if you don't review the implementation, then if you are not satisfied with the implementation, that will end up with demand letters going to platforms, and then it may lead to escalation to legal action. So this is the other key ingredient we are pushing for in the MOU, that there should be ongoing review system to see how the MOU is being implemented. So this is still ongoing with the platforms through the blessing of the Indonesian IP office. So hopefully, we get somewhere. The other point I want to mention is that there is a ASEAN IPR working initiative. So one of the key working items is online enforcement. So hopefully that can be another lobbying point on the Indonesian government to have this MOU in place. Thank you.
Thank you. So, are there many lawsuits in Indonesia against platformers?
Sorry, can you repeat the question?
Are there many lawsuits against platformers? Because in your slides, it says that that this will minimize the lawsuits against platformers.
No, they are not lawsuits, but we have sent, sometimes when we have to follow up because the platforms are not responsive, we have to send strong letters. Hopefully, we don't have to come to a point where we have to file a lawsuit against platformer. And also, I'm talking to a colleague in Singapore. They have come to a point where they are also losing patience with a platformer where they are contemplating a lawsuit, but that has not happened. So we are all waiting for a case study where somebody has taken a lawsuit against a platformer. So we're still waiting for a precedent on that.
Okay, thank you. インドネシアの状況をご紹介いただきましたけれども、MOU、トコペディアという先ほど来名前の出ているインドネシアの最大のプラットフォーマーがMOU を締結したというニュース、最近のニュースだったんですけれども、まだこれどうなるかわからないよというご紹介と、今実際ご紹介いただいたようなMOU の締結が検討されているということです。あとあれですね、海外からいろいろプレッシャーがかかっていることによって、多少より促進、模倣品対策が促進されている面もあるというご紹介だったかと思います。そして、ファイナリー、ベトナムですね、今後の取り組みについてですね、今年3月に政府が始めたプロジェクトで、2025年までに EC サイト上で模倣品の取引を撲滅するということが目標とされているというようなご紹介をいただいたのですが、これについてイエンさんに少し紹介していただきたいと思います。イエンさん、could you please introduce the Vietnamese project, the government project?
Thank you, Sakura-san, for your question. So, as you know, MOU hasn't been, signed for Vietnam yet. But discussions are underway, and we understand that there are initiatives coming from IP owners' communities to sign MOU under the governance of the Directorate of Market Surveillance under Ministry of Industry and Trade. So IP owners, they have an organization named VASIP, so Vietnam Association to Combat Counterfeits and IP Infringement. So VASIP has been having discussions with the Directorate of Market Management Bureau to sign MOU to tackle the serious online infringement, especially with e-commerce platforms. So we will have to see in the near future, hopefully, that an MOU will be signed in Vietnam. And separately from that, as Sugara-san just mentioned, the government in its latest effort has issued a project late in March this year, where the real aim of the project is to address the serious issue relating to counterfeit and consumer protection in e-commerce activities. And there are several solutions in that project to achieve the goal. In terms of the implementation of this program, is scheduled by the Ministry of Industry and Trade from this year until 2025, and the major activities will happen next year in 2024. But from now until the rest of this year, there are already training and seminars for government officials under this project. Now coming to one of the 6 solutions under that project, we think we would like to highlight here is to establish a centralized database for tackling counterfeits and protecting consumers in e-commerce activities. This database will include information from e-commerce trading platforms, e-transaction information systems, e-transaction data, and mechanism for controlling goods in e-transactions. So it looks like a centralized database between public and private sector to help, sharing information, sharing best practice in order to tackle the, online infringement more effectively. So I understand that, we don't really have much time here, so, I keep my answer short, but happy to answer any further questions relating to what I've just shared.
Thank you. Thank you for your comments. Maybe it's really until by 2025, Vietnamese will get maybe will have the great system even better than other countries. So it's really aggressive project, it seems. So we'll see. Thank you. ベトナムデータを共有するというようなプロジェクトもそのプロジェクトの中で計画されているということで、今現在はまだあまり整っていないけれども、2025年までにもしかするとすごく進んだシステムができるかもしれませんね。はい。それではですね、ちょっと残りの時間もぐぐっと少なくなっていることに気がつきましたので、クエスチョン4に移りたいと思います。国際的な模倣品対策のための国際連携としてどのような取り組みがなされるのが望ましいですかという点について各国に聞いていきたいと思います。これもう本当に皆様から自由なコメントをいただければと思いますが、私は個人的に日本なんかですと今、模倣品対策で税関さんと税関にいろいろやっていただいているんですけれども、他国の税関との間での情報共有がもう少しフレキシブルにできれば権利者にとってはより効果的な模倣品対策ができるのになと思う時は結構ありますので、例えばそういった国際連携が進めばいいなというようなことを考えたりしておりますが、他の皆様どのような国際連携が望ましいというふうにお考えか伺いたいのですが、最初そうですね、ビッグニッシュさんからもですね情報共有の必要性について、少しコメントをいただいているように思いますので、少しご紹介いただける。So, Vic, could you introduce if you have any experience that the information sharing at the customs or any other place?
Yes, I think that for border enforcement, the challenge we face in Singapore is that we are a transshipment hub. So a lot of goods from around the world enter Singapore first, and then they get transshipped out to other parts of the world. And this is where the border enforcement measures that I alluded to earlier in my keynote speech come into play. Our customs officials will investigate, and they have in the years that I've been in practice and before. I think the difficulty that I had when acting for IP rights owners in actually seizing the goods was that it only occurred to us when the goods entered Singapore that they contained counterfeit goods. And it was through the efforts of the Singapore Border Control that we were alerted that cargo on a ship had been found to be counterfeit, or at least suspected to be. Now, we knew where the ship came from and where was the port of embarkation. And even when we shared that information with that port authority, their point of view was that, well, we wouldn't know whether anything happened to the goods on the ship along the way from our port to yours. So we don't take responsibility for being the port that is the one that's shipping the goods out. But our purpose was we want to know who's the shipper in your country who shipped the goods out. And we had the issues of, well, this is not information that we are entitled to give to you or allowed to give to you at this point in time, and that maybe you'd have to go ahead and commence a lawsuit in our country to compel us to do that. I mean, there are some similarities to what the panelists from Indonesia has talked about in terms of data and information sharing. You know, and I think we can address that later on in the course of the rest of the time that we have. But another issue that we face with information sharing is, and these are legal procedural issues. If I actually have evidence of counterfeiting, that a particular merchant on an e-commerce platform has been counterfeiting in Singapore, I can obtain that information from the courts through the discovery process. Now, the real difficulty is information that I obtain from this process cannot be used in any other form of procedure in my country. So we have that information, but it cannot be used in a separate type of proceeding. There's an implied duty on the part of the parties in the lawsuit to not use this information outside of that lawsuit. So there are also difficulties with a lot of countries to share about sensitive information that arose in lawsuits in their country and to give that to us. We may all be talking about the same merchant here, who is perhaps known everywhere to be an infringer, but we can't share the information with each other if it came through the court system to some degree. And that will always be a problem with information sharing. And I recognize that as a lawyer, that there's not much we can do to force this issue. But perhaps there are other ways we can talk about what other types of information we can share that can assist. Yeah.
Thank you for your comments. I totally agree with you. エンフォースメント権利行使の際のですね、証拠の共有の話まで膨らませていただきましたけれども、はい、フィリピンのクリスティーナさんからもですね、税関における協力体制が必要であるといった、コメントをいただいてます。たくさん多くの観点でご指摘をいただいてます。はい。
Go ahead.
Yes, please.
Okay, so in the Philippines, while we have the National Committee on Intellectual Property Rights, where there is information sharing within the government agencies in the Philippines, however, we need a coordinated global network that can provide the ability to anticipate supply chain issues. And this will be very helpful in curbing the proliferation of counterfeit goods. The cooperation between and among customs and border control of each jurisdiction is crucial in this regard. Because like in the Philippines, we do not have manufacturing plants for counterfeit goods, but rather these counterfeit items are merely being imported into the Philippines. And in order to intercept cross-border crimes like counterfeiting, this will require a comprehensive operational response at the borders, since the borders are the first filter in order to stop illegal activities such as proliferation of counterfeit goods. This is only possible through technical and operational assistance between relevant government agencies of concerned states. And this being said, it is also important to note that we need not only the cooperation between relevant government agencies and its counterparts, but we also need to cooperate with other stakeholders, such as the private sectors, through the conduct of IP awareness campaigns and joint enforcement operations against the proliferation of counterfeit products. Another international cooperation that will help curb the proliferation of counterfeit goods is continuous capacity building to the public sector by the private sector or the brand owners themselves, since it is only the brand owners who can certify whether a product is genuine or counterfeit. For this reason, the conduct of product identification seminars and workshops by the brand owners to the law enforcement agents and public prosecutors is essential in order for the law enforcement agents and prosecutors to be capacitated on how to distinguish genuine items from counterfeit. And there are brand owners who are from different jurisdictions. That's why this collaboration is very crucial. And the Philippines also conducts a yearly IP colloquium for judges of the Philippines handling IP rights cases. And for these projects, we invite the private sector to do product identification workshops for judges. And we also invite judges from other jurisdictions in order to share their best practices in terms of IP litigation and IP adjudication and their latest case law on IP as part of information sharing. And in terms of the MOU, as I've mentioned, the Philippines has an existing MOU. However, we want to replicate the e-commerce MOU with online platforms within the ASEAN region through the ASEAN network of IP enforcement experts because, as mentioned by Carousel in session 1, it is hard for the platforms to have standards for each jurisdiction. And by the regional MOU, the platforms can agree and have a standard policy which can be implemented across all jurisdictions. And lastly, sharing of best practices such as this forum, the Judicial Symposium on IP, between and among different jurisdictions really helps a lot. So thank you.
Thank you for comments from various viewpoints. And さまざまなご指摘いただいたんですけれども、そうですね、インフォメーションシェアリング、情報共有という観点もそうですし、キャパシティビルディングも必要ですよというコメントをいただいています。また共通したルールが必要ですねというコメントも他の国の方からもいただいているんですが、まずキャパシティビルディングに関してはですね、ラオスのティパちゃんさんからも似た同様のコメントをいただいているかと思います。ティパちゃんさん、Do you have any comments regarding the international cooperation in the future?
Yeah, because about this question is now we don't have the specific course for the IP infringement. And I think we have definitely the IP to consider all about the infringement in now. And in the IP now, we don't have more expert specific about this part. And I think if we have more capacity building in the IP office, force, prosecutor, police, economic, and officer would be useful for us. In the about the cross border, because we are now we sharing the border with the 5 countries, and when the transfer the product is very easy. Maybe in Thailand to like just only 1 hour to transfer that. And I think if the cross border or its officer they have more knowledge about the IP dispute solutions or IP infringement, and they can understand more about the code or general products, and it would be substitute for the infringement in our country. And the last one, I think, but all of detail would be the same in Philippines. The right owner should be consider and certify all of that to our office or government to know what is the fake or what is the genuine. But if we have a more capacity building about this part, I think it would be better for the government officer to handle with this state. And the last one is about the sharing information. I think it would be helpful if if we have program or platform to sharing information about the counterfeit product or what is the fake or genuine or some data collections about the fake product in the system or the platform. And we can be sharing and cooperation with the ASEAN countries. And I think if we have the information sharing or guideline, it will be helpful for the government to handle this the IP infringement in my country. I think it has like the mechanism like this. I think not only in Laos but in ASEAN countries will be helpful for handle about the IP infringement. Yeah, that's all for my comment.
Thank you for your comments. やはり共通のガイドラインなんかがあるといいよねというコメントもいただいております。同様のコメントがですね、マレーシアのカラさんからも、considering the rest of the time, we are about 8 minutes left, so could you please make a brief comments about the international cooperation?
Yes, I guess especially when it comes to e-commerce platform, where the sellers can be from many countries and not only from your territorial country. So information will be very crucial for us to pursue any kind of investigations. So in this matter, I feel that international cooperation is very critically important. So that we can gather the information necessary or pass any information that's related to the agency which is relevant in their respective countries. And it is also, it would be ideally good if we can share the best practices among the region, especially in the digital and borderless era that trade is seamless at the moment. And this symposium has given us that opportunity, so I thank the organizer. For having this, at least we can listen to all the various different territorial best practices that has been implemented in among the ASEAN region. And moving forward, maybe we should need or we should have some international guidelines or codes where all the e-commerce platforms could adhere to and follow. So at least these will give a guidance to all the countries to have a basic layout as to what e-commerce should follow and adhere to. Uniform code will be ideally good. I think Mr. Vignesh mentioned this in his keynote address as well. So that would be the way forward. That's all from me.
Thank you. Thank you for your comments. And maybe definitely the Serena-san from Caluso, you agree with the necessity of the international kind of guideline or the common rules for e-platformers?
So I am of two minds in relation to this. Of course, I see the benefits as well, but there are also difficulties, and what we have observed as a platform is that a lot of bad actors now are taking it out of certain platforms, potentially moving to messaging platforms as well. Would we consider defining messaging platforms as e-commerce platforms? So as we get into the nitty-gritty of these things and we start dicing it up, it gets very difficult or tricky in that sense when it comes to setting out specific codified rules, which may not apply simply because the term of platforms and how bad actors move from one to the other so freely could really differ between, say, just Carousel itself or Lazada or Tokopedia, where they may have more merchant-facing users as well. So yes, we think it could be beneficial, but the recommendation, maybe at least on my point, is actually for it to be more outcome-based than for it to be too prescriptive, where it may not work for one platform and it may only work for platform B, for example. But of course, sharing of this information between platforms and even cross-border, having this framework is very important, and would be glad to also hear from the panelists, because it gives platform owners also the protection similar to the safe harbor laws, where if there's a position that if we do share certain information, it absolves the platform owners from data protection considerations, where some platforms, maybe for Carousel, particularly where it's consumer to consumer, or messaging apps where it's also similarly more consumer to consumer based and business based, that they have the ability to share this information and to prevent repeated bad actors from moving across different platforms, I think that would definitely be beneficial. So the idea, I think, is great. How we execute might be something that needs more conversation on.
Thank you.
I would like to add something to this, and I think Ms. Serena has touched on something that's very important here, that a bad actor will always find a way to sell counterfeit products. They will always be looking for a way out. And if you have this common code across all the platforms, the bad actors know exactly what's going to happen to them on the e-commerce platforms. I've been chasing after these people on behalf of rights owners for 20 years already. I know they'll always be moving somewhere where the regulation is lax. All right? When I first started in practice, they used to be physically available. They used to be physically visible to the eye. You knew where they were. You knew how to catch them. Now they've gone perhaps into the online marketplace and have found themselves hidden there. And perhaps they enjoy a certain level of anonymity. Perhaps they think that that's the case. But as Ms. Serena has already said, how do you define an e-commerce platform? Would you consider Facebook an e-commerce platform if I were to sell something on Telegram and or online or Kakao or on WeChat? Would that make me is that a marketplace as well? Where's the regulation for that? Because when we look at these regulations for e-commerce platforms, and I think when we talk about platforms, we seem to have limited the understanding of platforms just to a few major actors as well. And we do that in Singapore as well. We do that as well in Singapore, that we've only looked at a current group. And we only talk about regulating this group. But I think the bigger thing that we have to look at is really the online sale of counterfeit products. And in a borderless world, and I think we've talked about this, Ms. Kala alluded to this as well, we have a region which is connected by land borders. And while I alluded to the issues that we face in Singapore as a port, you must remember that Singapore is the southernmost tip of continental Asia. So the whole of continental Asia is actually connected by land. Singapore through the causeway to Malaysia. From Malaysia you can get to Thailand. I'm sure with many friends from Southeast Asia and our region, we can cross into each other's country very easily by land. And that's how how difficult it is to enforce borders if we are saying they're coming through the land borders. Information sharing is important. There are also difficulties because as you cross borders, the definitions of counterfeit or infringing acts, except for several acts, differ as well. So how are you going to have a common set of regulations for an e-commerce platform to comply with when all the countries which share the borders don't have the same laws? That to me will always be the difficulty. It's nice to have, I don't think it's realistic. That's my view on this.
Thank you for your comments. 共通のガイドラインといっても非常に難しいよねというところですかね。確かにビグニッシュさんコメントされた通りですね、必ず抜け道を探して悪いことをする人がいるというところを考えると共通のルールというのが必ずしもいいわけじゃないよねというところも興味深いコメントかなと思います。情報共有といっても、各国の侵害であったり模倣品であったりというところの定義から変わってきたりする部分もあるというところもなかなか国際協力といっても簡単じゃない部分もあるかと思います。じゃあちょっと残り時間があれなので最後にタイのナバラートさんからですね、今後のインターナショナルコーポレーションについてのコメントをいただければと思います。基調講演でも少し触れていただいていたかと思いますけれども、どのような取り組みが望ましいとお考えかパブリックの立場からコメントいただければと思います。
Thank you for the question. Actually, as everybody understand that international cooperation is very important and very useful because as a witness has said that in each country have different law and regulation and practices. Yeah, I agree that information sharing is very important, and it's one of the international cooperation, especially with this area is the custom across the board. Is important also. I also like to have a comment that a capacity building on online enforcement, which could be the expert meeting or share comments on how enforce online infringing that in each country can practice or can be. That's I think it's another information sharing that we need to initiate. And another one is exchange the best practices. What are the best practices? Manage or control the counterfeit goods for stakeholders. Also are the good initiatives. Thank you.
Thank you.
Can I add one comment for international cooperation?
Yes, please. Just a brief comment, please.
So I think the most important thing is we already have an ASEAN IPR action plan. So this is an action plan where all the ASEAN government, Indonesia, Singapore, Malaysia, Vietnam, Thailand, all committed to. They committed to have an IPR online enforcement system, a guideline. So this is a good way to hold the countries to their commitment. And the problem with most of these countries is that sometimes they say they want to do it, but they're slow in doing it. And when they're slow in doing it, the IPR owners suffer. So the best way is to hold them to this commitment. And the best way to hold them to this commitment are foreign governments who are aware of these guidelines and remind them of these guidelines. So I think the US government, the European government, even the Korean government has done that. I'm sure even the Japanese government has done that too. So you need to hold them, and the best way to lead this private-public partnership is that the lead must be taken by the government themselves. Only when you take this lead by the government, then the other people will fall in line and will respect the initiative. So it's still back to the government taking this initiative, and the only way to do this is to push the government to take this lead because of the commitment they make to the ASEAN IPR guideline. And yes, I think that's the only way to do that. So I think this is a very important international commitment, at least for the regional aspect. Thank you.
Okay, thank you. Thank you for your comments, and thank you for introducing us the ASEAN IPR Action Plan, which is, yes, I agree, it's a great idea and expecting a better practice. So thank you for your time, for such a long time, and I hope this GSHIP will become the best, one of the best place to sharing the information each other. ではこれでセッション2終わらせていただきたいと思います。お疲れ様でした。ありがとうございました。
以上でパネルディスカッションワーキングセッション2模倣品対策のための官民連携国際連携を終了させていただきます。